All right, you're live.
Good evening. Welcome to the Discipline Matrix Ad Hoc. Today is January 22nd. We're getting going at 6:04 p.m. We're joined here with Deacon Lyles. Great to see you, sir.
Good to
Acting
be
Captain
seen.
Hubbard, as always, both you gentlemen. We've taken a couple weeks off and back at it. And we're going to pick up where we left off. We are going to be recapping quite a few things. We have shelved a couple of items for review, and then we took a couple weeks off. Last session off because of our community town hall, and so yeah, doing well. Hope everybody is doing well around here, and I will pass it to Acting Captain Hubbard to pick us up where we left off.
Great, thank you. Hoping you can see my screen.
Yes, sir.
Okay, great. All right. We talked a lot about subversive organizations. There is no change to this section. However, we did have a spin-off discussion about what if it's not subversive. So remember, the definition is of subversive is one that is attempting to overthrow a government authority. And we wanted to cover organizations that aren't necessarily subversive, but still can bring disrepute to the city of Oakland and the Oakland Police Department and the profession as a whole. So did a lot of research on this. Haven't identified the actual section yet, but it's titled Associations with Disreputable Organization. And it's, I'll go ahead and read it, excuse me. No member or employee shall knowingly join, affiliate with, support, or subscribe to any organization, group, or association that engages in activities, conduct, or practices that bring disrepute to the Oakland Police Department, the city of Oakland, or the policing profession. Such groups include, but are not limited to, organizations that engage in illegal activities or unethical practices, promote discrimination, hatred, or intolerance based on any protected characteristic under local, state, or federal law, including race, color, national origin, sex, including gender identity and expression, sexual orientation, religion, disability, or age. Advocate or incite violence or acts of disorder against individuals, groups, or institutions. Operate in a manner inconsistent with the values, mission, and standards of the Oakland Police Department. Additionally, any organization that engages in conduct or public messaging detrimental to the trust and integrity of the Oakland Police Department may be deemed disreputable. Such a designation will be based on the preponderance evidence and determined by competent authority within the department, including the chief of police or their authorized designee. Membership or affiliation with such organizations strictly prohibited unless such involvement is necessary for official duties, supported by a lawful investigative purpose, and explicitly authorized in writing by the chief of police or a designated official. The prohibition extends to actions including but not limited to financial or in-kind support of such organizations, public endorsements or displays of symbols, insignia, or paraphernalia associated with such organizations while on duty or representing the department, or participating in events, meetings, or activities promoting the organization's objectives that conflict with this rule. A lot going on there.
Yes, think it's good. Interested to see if Deacon Laws have any thoughts on it. We had a pretty extensive discussion about this, kind of went down that rabbit hole, and this does cover a lot of what I remember we discussed, and seems pretty comprehensive to me. I'm wondering if there's any other questions that folks have.
I don't have any.
You know, no, I'll hold my thoughts right now. You know, just given the topic, and I think we had quite a bit of a discussion around January 6th, and it's just, and I think this is pretty thorough, given all of that context as well. just I'm curious just how law enforcement communities are taking just the the pardoning of some of the folks that committed some crimes against officers that day, and how that might blur the lines of what's defined as a submissive organization. I mean, submersive organization. Excuse me. But I mean, and actually, I wanted to point out that I'm glad that it's clear that in this we're talking very specifically to Oakland and the Oakland Police Department. Regardless of what's going on, kind of on the national level. But just kind of thoughts around that.
I haven't had a discussion with any of my colleagues about what happened since Monday. It is interesting, surprising to say the least, but we have not had a conversation. As I wrote this, I'm glad I had an extra week just to think this through. It's trying to think like, okay, what are our members likely? How are our members likely to violate this section? And it's probably by way of social media, and
Mm.
there could be ignorance that is argued there as like, oh, I subscribe because of X, Y, and Z. I had no idea that they were spreading whatever is outlined here. But the support or subscribe to any organization is key, because regardless of financial contributions, or even I never comment or I never like anything, but the subscription too, I think, is what's key here. So that's social media is the one thing that I really focused on when I wrote this.
Yeah. No, I like this a lot, and I was just when the news came out on Monday, I just I couldn't help but think about this that we were talking about, right? And just like how you know I wouldn't want that mixed messaging to undermine what we're trying to do here. I guess is what I'm trying to get to as well, and just for folks to be clear that hey, we know there's maybe some mixed messaging around this, but this is the standard that we expect for the department.
Right.
Yeah, great, awesome, thank you.
Okay. Oh, I was expecting a broader discussion on this, so I'm good. We can move on. Okay. Well, I let it sit. I mean, in fairness to you all, I didn't send this out to you beforehand. So after our meeting tonight, I'll send you this so maybe you can digest it more before our next meeting.
Great, thank
All
you.
right. We had a lengthy discussion around truthfulness, and I know we went back and forth on, like intent and, perception versus actual untruthfulness. And we decided not to change anything within the truthfulness manual of rules section. However, we had a discussion about juvenile interaction and custodial interrogations. I'm not 100% sold on this title because it makes it sound one and the same, as in it has to be a juvenile interaction and custodial interrogations. Maybe it can be or there, just because I am really talking about two different things. But I'll go ahead and read it. No member employee shall use coercive, deceptive, or manipulative tactics in interactions with juveniles, and this is persons 17 years of age or younger, whether during a custodial interrogation, investigations, or other engagements. Prohibit conduct employing ruses, misrepresentations, or deceitful tactics to obtain compliance, information, or confessions, using threats, promises of leniency, or implied consequences to illicit statements or cooperation. Engaging in physical or verbal intimidation intended to induce fear, distress, or compliance, using physical harm or unreasonable force except as permitted under department policies for lawful and necessary use of force. Custodial interrogations, members and employees are prohibited from using threats, physical harm, deception, or psychologically manipulative tactics during custodial interrogations of juveniles. Additionally, custodial interrogations don't comply with the following requirements. Parental or guardian notification. Members must make reasonable efforts to notify a juvenile's parents or guardian prior to the interrogation, unless doing so would pose a risk to public safety or the investigation. Recording requirement. All custodial interrogations of juveniles shall be electronically recorded in their entirety in compliance with California Penal Code 859.5. Advisement of rights. Members must advise juveniles other Miranda rights in a manner appropriate to their level of understanding. Also 625.6 of the W&I code, welfare and institutions, juvenile consultation with an attorney. So effective January 1st of 2021, this section requires that juveniles 17 years old or younger who are under arrest must consult with an attorney by phone, video, or in person before they can waive their Miranda rights and provide a statement. The Alameda County Public Defender's Office staff, I put the hotline in there. I might remove that because it's in a different policy, but it allows for 24 hours on-call attorney. And then questions about juvenile arrest and attorney consultation should be directed to this intake desk that we have here. I just put this as a note. Doesn't really apply for the manual of rules, but however. So exceptions to prohibited contact: when there is reasonable belief of an imminent threat to life or property, members may employ questioning or action strictly limited to addressing the immediate threat. Any deviation from these guidelines must be authorized in writing by a commanding officer or designee and must be necessary for a lawful investigative purpose. And then general conduct with juveniles, members and employees must conduct themselves in a manner that respects the developmental stage and vulnerability of juveniles, ensuring that interactions do not undermine the trust and integrity of the Oakland Police Department. Again, a lot going on there.
Yeah. I have a question. Do you make a distinction between interview and interrogation? And the question would be, would an interview be appropriate without notifying the parent? Or do you think that interview and interrogation, both of them have to follow what you just said here?
Yeah, that's a great question. And yeah, I probably need to just clean this up a little bit more, because regarding their parents specifically, it's under the custodial interrogation, where that then assumes that they're in custody. They're actually under arrest.
Okay.
Going back to the top here, though, I just talk about kind of general, just this is where it does bleed over a little.
Yeah.
Regardless if they're in custody, all interactions need to be free from any of these prohibiting.
Okay. So if we want to say all interaction, I think it would be wise to say juvenile interactions, interviews or interviews, juvenile interactions, comma, interviews or custodial interrogations.
That's the heading.
Yeah, I guess what I'm driving at is that, you can have somebody in protective custody, but I'm not interrogating. I'm not trying to impeach the person's statement or whatever, but I'm just generally asking questions, which in a sly way is what you're saying they should not be doing, because that's a ruse. So if we want to make sure that the officers understand that, we should use the word interview and interrogations. Person taking a juvenile in custody, it doesn't have to be under arrest. They could be there because of protective custody. So it's not an arrest. So, but what we're driving at least correct me if I'm wrong, what we're driving at, we don't want the officer to be using any kind of sleight of hand tricks in their discussion with the person that's in juvenile custody, not in an arrest, but in juvenile custody, and then start asking questions and enticing them, maybe buy them in a candy bar so they can tell you what's going on. We don't want any of that. Am I correct? If that's true, then we ought to say interview or interrogation, or interrogation.
Yeah, that makes sense to me. There. Yeah. Let me just think through this. Yeah, I'll probably, yeah, it's, yeah, and what you said is spot on. I added interviews here, but this is just general kind of coercive, deceptive, or manipulative tactics.
Yeah.
Interactions, whether custodial interviews, investigations, or other engagements. So basically, under no circumstance should you do that.
Yeah. And if you don't say it here, then you leave a gap where someone's saying, well, I was interviewing. I wasn't interrogating them.
Right.
And so.
That's a great point. And Deacon, you just said something right now that made me think of something never thought of before is where do like protective custodies of a Jew, does they even fall under, does that even considered like detaining, or is that just is that a classification of its own? Like you see if you're getting a kid like from, protecting them from maybe an attacker and their parents aren't there, and at that point you're trying to find who their parents are, things like how does that process work? I'm just unfamiliar with that. Well, when you said that protective custody, I thought of that for the first time. Like, oh yeah, technically there's times when they're not being detained or a suspect, right? They're actually there for their own protection.
Well, Welfare Institution Code gives police officers a right to take someone in protective custody if they don't have any parental support or someone caring for them. So you can do that. And only our imaginations can go how people can manipulate juveniles to do criminal acts. And so an officer can believe that this juvenile is being taken advantage of, and I'm taking him into protective custody. He's not under arrest, but I'm taking him under protective custody. And then while there, I'm just talking to him and just to find out what's going on, and use some kind of coercive methodology so they end up saying something that could end up being that they are arrested.
Yeah.
So we don't want any.
We don't want that, right? Yeah.
No.
Especially if in that state they'd be vulnerable, kind of like in distress or in crisis, maybe. So
yeah, and and somebody on the street at 14, 15 years old can be or look to be streetwise, very sharp, very smart, very together, and know what's going on. But after sitting in the station for 2 hours, I've seen it 100 times, man.
Yeah.
They then become in the third grade. They don't know what's going on.
Yeah.
And do we feel like if by adding interviews it covers that, or do we have to even explicitly say even in protective custody?
That's even a better. That's an improvement. But I think we ought to let Captain Brian think about it some more, and I think somehow you ought to add in protective custody, even in cases of protective custody. Officers who understand the juvenile, the Welfare and Institution Code juvenile section, they will get what's going on. They would definitely understand.
Right. Excellent.
Was it confusing on how I kind of, this all has a general theme of somewhat of interrogation, and so it combines just general conduct. So let's say that my overall demeanor is less than becoming with this, and I don't with this juvenile. I'm not trying to gather information from them or use it against them as this would imply. I'm just not kind. And so the question is, should there be, so we have a section under general demeanor, which is a common sustained manual of rule section. Should we under general demeanor have a special section just on how we deal with juveniles?
That is a great question.
Yeah, I don't. I
I mean,
think
I would say, yeah.
we should err on the side of more information as opposed to less. In my mind. So it, you know, I don't know how we legislate kindness, but they ought to be, you know, just respectful.
Mhm.
You know,
So it would be mirroring kind of at the bottom of this part that you're just looking at, having something that kind of aligned with that language there, but in the general conduct area.
Yeah, and what we're implying here is that it adds more weight, as in when you talk to someone poorly, that's one thing, but a juvenile that has more weight. I mean, because we talked about how, you know, it's the withdrawals and deposits. I mean, you can really ruin a child's a juvenile's perception of the police for the rest of their life based on that interaction versus an adult who might have more resiliency. One, they're both unacceptable, but we're saying, and what we're getting here too is if we have a conduct towards a juvenile that's unbecoming, there's heavier discipline that's associated with it versus an adult.
yeah,
That makes sense. No, the trusting and the community trust is a big thing because that gets fostered at a young age, right? And if you're already hearing and feeling and growing up in an environment, a community that distrusts and has distrust for law enforcement, those very early interactions could have dire consequences. And the fact of the matter, too, is also acknowledging, and I think this is a training piece, Captain, is that like I've seen many scenes and many interactions between juveniles and law enforcement officers. I'm sure you have, in which the juveniles themselves were using particularly really foul, bad, disrespectful language towards the officers, right? And it's a mix of just kind of like spewing the disdain for enforcement, but also with this kind of like really teenage juvenile twist of like you want to strangle them like Bart Simpson, like come here you little juvenile, right? And so it's and working with young people and doing youth development my whole life, it's like, yeah, young people will drive you to the point of wanting to strangle them, right? And so in particularly, those are actual very teachable moments when a young person is testing an officer's patience, maybe calling them the worst of words, right? And how an officer interacts with that juvenile also carries a lot, because if they feed into that and are a-holes with it, then that kind of feeds in and they're just like, see, they're exactly what I thought you were, right? Or what I was taught you were. Whereas those are some real teachable moments for somebody just to like show some humanity and be like, yep, call me whatever you want. It's all right, sir. We're doing what we need to do. We're professional, and it's not going to like, I'm going to have thicker skin than that, especially when it comes to a kid being just a little punk kid. So but I think there's a lot of training areas around that as well too, as we look at this. And I do appreciate, I think when we talked about adding this section for juveniles, this is what we envisioned, so I thank you for this, man. It's pretty expensive. And yeah, I think it read pretty clearly when you read through it, to answer your original question.
Okay. Yeah, great. I will send this all to you in an email just so you have time to digest it again, and I'll make some adjustments. Okay, moving right along here. The last thing we talked about, and this I know will take us some time here, but we talked about use of force, and our current language within use of force is just one section. This is 370.27, and this is a class 1 violation, and there's no other section for this. But it just says the use of physical force level 1 through 4 shall be restricted to circumstances specified by department policies and laws. So as you recall, I was giving the example of there's no in between here. So you can have an officer who uses excessive force against someone, and there's mitigating and aggravating factors there on what type of discipline. But let's say they use excessive force. Let's take the most extreme version. Then on the other side of the spectrum, you have an officer whose tactics were not great, which led them to use force, but there was no injury. And there was nothing traumatic about it. Those two examples carry equal weight because we only have this one section, right? So I made some notes here just so you know where I was going with this, but so my goal was to make two sections, one for the heavier class one, where it's almost excessive force. That argument's there, or something grossly negligent about it. And then there's a class two version where it still carries weight, but it's not as heavy. So I wanted to reduce the broadness of it. And I wanted to distinguish between gross negligence and just lawful force applied with tactical deficiencies. And I created a class one. So this is gross misuse or negligence versus tactical deficiencies, where the difference is severe misconduct, reckless or unlawful force over poor judgment or training gaps requiring corrective action. So
that also could cover like maybe a procedural misstep or something.
Yeah, exactly. Because right now it doesn't really have a home. Sometimes we have, for procedural missteps, try to frame it as more of a performance of duty issue, and that there's an argument there, but it's hard when the underlying offense is use of force. We're automatically drawn to this section. So we looked at the different levels, and I'll go over those levels again with you, the outcome of the action, and then just adherence to department protocols. And of course, I wanted to be fair, accountable, and also just for a continuous improvement. And then, public trust and also officer integrity here. So those were my overarching goals. Before I go over the actual sections, I'm going to go back to this, and I don't think I sent you or showed this to you, but I did talk about it. I'll just give you an example. So we have 4 levels of force: a level 1 use of force, any use of force resulting in death, any intentional firearm discharge at a person regardless of injury, any force which creates a substantial risk of causing death, the use of a vehicle by a member to intentionally strike a suspect with or without injury, or serious bodily injury, including loss of consciousness or protracted impairment. Okay, so that's the most extreme version of our force. And if any of those happen within a level 1, then we actually call out our investigations division and internal affairs bureau to investigate. And we had one a few weeks ago, and that's exactly what happened. It was a use of force. Officer discharged their firearm, and we did a level 1 investigation. Yep.
Captain, and for the class 1 and class 2 designations, would that apply for all levels or only like the 3 and 4? These other 2 are strictly would be simply class 1s, or how would that work? Or would that be for each level have class 1 and class 2 designations?
Yeah, that's a great question. So again, I mean, I'll just go ahead and jump to it here. It's we did talk about, like, should we make a class? I really wrestled with this the past 2 weeks. So we talked about level 3s and level 4s being less severe force. The problem with that is that what we would consider less severe, based on the outcome only, could be quite traumatizing for the subject of the force or an onlooker. And for example, I'll use the pointing of a firearm. The pointing of a firearm is a use of force under level 4, and we might think it's a pretty benign situation. However, it can be life-changing for a person to have a firearm pointed at them. So I don't want to diminish the heaviness of such action by the officer by saying, well, if you do that, then it's just a class 2. So I want it to be all levels have the ability to be a class 1 violation, but all levels also could be a class 2.
Okay.
Example, let's say for the level 1, let's say that an officer discharged their firearm, but they didn't announce themselves as the police prior to doing so. It might not change the outcome or the justification be behind the use of force. However, it does, have pretty significant weight. But I also want to, how impactful was it? Is it a class 1 violation impactful, or is it a class 2? You should do that next time, but it didn't change the outcome because this subject did have a firearm and they were firing at the officer, let's say. So it depends on which category we would investigate it as.
Well, I think you ought to have that flexibility.
Right.
At some point, we want to get to. I want to get to a point where the community trusts the Oakland Police Department to do the highest, best ethical action, not just defend the officer in their behavior. Now, you use an example of, you know, the officer discharges firearm, didn't announce that they were a police officer. Well, we have that case, I believe it was in St. Louis, where the woman was shot early in the morning, knocking on the door. No one announced themselves, you know, and then the boyfriend pulls out a gun and I think he fired the first round, and then ultimately the woman was killed. His girlfriend, a wife, was killed. But there's no evidence that the officers announced themselves. Okay. So I'm hoping at some point that the police department gets to where they say, look, we can't even, no one in the apartment building, they heard you knocking on the door, banging on the door, but they didn't hear anyone say St. Louis Police Department. You know, police officers, they didn't hear any of that. So we have to just trust at some point that the police will do the highest, best ethical job in the investigation, and then make the appropriate discipline.
Yeah.
But you got to be able to go up and down, because I don't know. I'm trying to put myself in that situation. You got to announce yourself because that's the law. But I'm unholstering my weapon. You know, this is not a fair fight. I'm not trying. This is not a quick jaw contest, you know. But you gotta announce, you know, who you are. Yeah. So the investigation has to have that kind of broadness to it.
Right. Right. Yeah, and that's great. And that's why the class 1, class 2 categories really help in this situation.
Right.
Yeah. And I think I've stated before, in the disciplinary process, having that tool would be very helpful if it reaches the commission as well.
The problem has been that the union gets involved and think that no matter what the situation is, the officer's always innocent. And there you have the problem. Let's call it like it is.
Mm. Well, my only question, Captain, was going to say, how fast can we get these class 2 violations in here, man? We can't wait any longer. You know, it's that actually for me isn't an urgent matter. And I know we've had some discussions around this as well too. And but I know there's quite a lengthy process once we finalize these recommendations to get all these things approved. But certainly I'm willing and would support looking at identifying the top MOR violations that maybe you, and maybe there's a different discussion of identifying the top MOR violations that you think would require a class 1 and class 2 designation in this way, and try to figure out what we can do to start fast tracking some of that process while we look at the rest of the MORs that we've been updating. I don't know, side thought, but yeah.
Use of force is definitely one, and then probably care of prisoner is the other one.
Mm-hmm.
Yeah.
And we've recently, had to deal with it. So certainly, yep, got my support on that for sure.
Okay, so I'll just go through the class 1 and we can talk further about it. So this is the gross misuse or negligence section. The use of physical force, so this is levels 1 through 4, that is unreasonable, unnecessary, disproportionate, or unlawful due to gross negligence or intentional misconduct, which would constitute a class 1. This conduct includes, but is not limited to, negligent or reckless actions that result in serious bodily injury, death, or regardless of intent, unlawful or unjustified application of force, even if no serious injury occurs where the force was not consistent with department policy or law, willful or negligent use of force that unnecessarily escalates the situation or creates an undue risk to the safety of the officer, the subject, or the public, or any use of force deemed grossly disproportionate to the threat or resistance encountered. So the principles guiding this: severity of the misconduct evaluated in conjunction with the levels of force, while level 1 use of force generally reflect the highest degree of severity, firearm discharge resulting in death, for example, mitigating or aggravating circumstances, we look at intent, recklessness, or compliance with training may adjust the level of disciplinary action. So it's not all or nothing, because I don't want to make this suggest that it's excessive force, because if we're saying excessive force, that to me is automatic termination. And also California Post would probably or likely decertify the officer. So it could fall short of that, where we would say you did not follow our very strict and progressive DGO K3 policy, which is use of force. It doesn't have to rise to the level of excessive. But for class 2 violations, we have physical force, tactical deficiencies. I don't really like the word tactical deficiencies, but that's all I can think of in the moment.
What does that mean?
Well, it to me, it's like I want to call it more procedural violations with the policy, as in like you didn't follow all the steps leading to or after the force is used. And it more procedural missteps than anything, but not a constitutional violation of a use of force. So a little bit short of that. Yeah. It's a little bit developed here. So this is the use of physical force levels 1 through 4 that are deemed reasonable, proportional, lawful, but where the officer's tactics, decisions, or situation awareness contributed to the need for force or escalated the encounter unnecessarily. And this constitutes a class 2 violation.
See, I think that there in lines where at least the cases that get national attention is when some officer puts himself in harm's way, when it would have been wise just to wait to get more cover there, or etc.
Yeah, no, you're right. And it depending on how severe that it was, that could also be a class 1. But I reviewed a case today, for example, where the officers were delayed in handcuffing the subject. And as a result, the subject tried to run and force was used. The force, as I saw it, was reasonable, but as it was a tactical error, I was like, well, if you handcuff the guy sooner, based on the circumstances, you could have, it would have mitigated then what happened 5 minutes later of him running and then force being used. So that's one where it's like, I don't want to, you're not violating our use of force policy, but just in the umbrella of the force, you could have been better. Yeah. And I'll expand on this a little bit more. So such conduct includes, but is not limited to, failure to employ de-escalation techniques when safe and practical, leading to avoidable use of force situations, poor tactical decisions or coordination that unnecessarily place the officer, other members, or subjects at risk, even if the force applied is lawful, a use of force resulting from inadequate adherence to departmental training or situational protocols, such as improper positioning or failure to assess threats accurately, unnecessary use of force at lower levels, pointing the firearm, or use of control holds when other tactics may have sufficed. And I'll explain what that means. Sometimes, especially when you get experts who, like our defensive tactics experts, sometimes they look at things and say, what you did was appropriate, but there was a better way, and we teach you that better way by X, Y, and Z. That would apply here. It's just the choice you made was not excessive. It just there's a more appropriate method of doing what you did, and that would fall under number 4. So the guiding principles for this tactical errors highlighting the need for improvement without labeling the force as unlawful or unjustified. Violations of this category recognize the importance of continuous improvement and adherence to training with disciplinary actions reflecting the severity of the error. I know it's kind of confusing, and I really did struggle with this just because it's out of the norm of what we would do here. But just recalling my memory of how we came to decisions on use of force, a lot of them could have been categorized here as opposed to calling it a class 1 severe, use of force violation. I'll let you sit on that. There's a lot going on there too.
Explain the class 2 violation one more time for me,
This section or just in general?
just in general.
Yeah, so class twos are not as severe, and it definitely holds less weight for discipline. However, we have another policy that talks about informal resolutions to this, and here's how this would apply. I think we all know that internal investigations are thorough that we do here, but also very costly. And there's an opportunity cost, not only financially, but also the use of time. So if a sergeant, for example, is reviewing body worn camera of a use of force, and the sergeant makes a determination, it's like, you know what, you did this use of force, let's say physical prowess, and I think you could have done better with that. They are then forced to open up an internal affairs investigation because it's a class 1 offense. And now we're going to spend a lot of time and resources investigating it. With a class 2, however, the sergeant can say, you know what, you should have done better. I am going to counsel you, I'm going to train you, and I'm going to document that, but treat it as a class 2 offense. So you're not going to walk away scot-free, but you're going to actually learn a lesson right then and there, go to additional training, and then we can move on and hopefully learn from that mistake. So that's the other parts of class 2s, is that they can be handled formally, but also informally. So it doesn't have to be a full-blown investigation into the matter as a class 1 would require.
Do you have any fear that class 1s will be made into class 2s just to avoid disciplinary action and the sergeant being a favored good guy sergeant?
Absolutely.
So that's my concern. Then we're here because, rightly or wrongly, depends on where you stand on the spectrum, and no one has to say where they stand. Rightly or wrongly, the overwhelming perception is that Oakland Police Department has not held their folks accountable.
Yeah.
That's so the only reason why we got this oversight committee and these is because of that. You know, if Oakland's disciplinary action processes worked, sergeant, lieutenants, captains, deputy chiefs, if it internal affairs, if it worked 60% of the time, we wouldn't be here.
Yeah.
So that's what's the issue is if we say is it any way we can review these sergeants' decision for class 2s by a lieutenant or captain, so the sergeant can be reviewed and say, look, man, everything that comes across your desk, you're making them into class 2s. You're hurting us as opposed to helping us. Do you get what I'm saying? Is any way that the sergeants their disciplinary action can be reviewed and rated?
Yeah. Yeah, that's a great question, and that coincidentally is another project that I'm working on. We do have a policy that talks about it, but it's not, there's no review process, and that's an area that I want to go to. And quite simply, if I give officer so and so training in a supervisory note file for what I did, I have to present the evidence to at least one commanding officer higher than myself, so they can assess for bias if I'm just doing it to pick on the officer, and or to confirm that my observations are correct, where it actually is a class 2 violation as opposed to gross negligence where it should be a class 1. So there is an accountability mechanism built in.
So that's what we ought to do.
Yes.
That we ought to say or think, like, before we change this,
Yeah.
we have to establish that we're not creating another loophole where where the very thing we want to improve our department over, we're working against that goal.
Yeah.
So and I'm thinking lieutenants ought to be able to judge that, right?
Yeah. Yes. Or captain. Sure. Yes.
Well, if the captain's doing it, what is the lieutenant doing?
Well, sometimes the lieutenant, it's not that, it's sometimes the lieutenants are the ones who's actually reviewing the use of force and issuing so it's just one rank higher. So that's all I'm saying. Yeah.
Yeah. Well, I guess what I'm saying is that I want the lieutenants to do the reviewing of the sergeants.
Yes.
Because I want the captains to review the lieutenants.
Yeah. Yeah.
I don't want the sergeant's decision to go straight to the captain. I want the lieutenant, this is hard work. Get in there and do it.
Yeah.
Does that make sense?
It does. What I meant was it's just whoever makes a decision is just one rank higher. Sometimes it's the lieutenant who are doing audits. That's all. But we're saying the same thing. I just confused by but yes, I totally agree.
So I think before we change this, we change the apparatus of check and balance. And then we in other words, we correct it from the top and then go down. And then when you get to the sergeant, yes, sergeant, you do have that latitude. Yes, you can do that.
VT3, that's the policy. So that might be a discussion for next week. I'll show you that policy and talk about where I want to go with that.
All right.
Chair, I think there is a raised hand in the chat room.
There is, Miss Risa.
Yeah, it was a while ago. After you moved on, I put it in the question and answers. It was related to the juveniles. My question was, does interaction include interview and interrogation? And if yes, does listing specifics rather than just saying all interactions open up loopholes? Because I was listening to the discussion and people kept saying, well, what about this and what about that? And I'm wondering if that's solvable by just putting all juvenile interactions. And the chat is closed because usually I chat those questions in there and sometimes you'll notice there. So I don't know what's easier for you all.
Yeah, no, I appreciate the question. And so going back up here, I did kind of keep it initially broad. Coercive, deceptive, or manipulative tactics in interactions. That's the theme behind that. However, I wanted to get a little, so I didn't want, and it's a great question because I didn't want officers to say, well, it's only when I'm asserting my authority, those interactions. I wanted to be clear that it is indeed all interactions to include custodial interrogations, interviews, protective custody, investigations, or other engagements. I didn't want to complicate it by adding those things, but I also didn't want anyone to say, well, I'm not asserting my authority. The juvenile is free to leave. Therefore, I can just do whatever I want.
Mm.
But any suggestions to develop that further, I'll be happy to entertain that as I work on this some more.
Excellent. Thank you, Captain. And sorry about that, Risa. Didn't see your hand up there. But glad you are here and participating. We'll definitely be noticing the raised hand. And Chief of Staff Montgomery, I'm not sure. We said the chat might be.
Yeah.
There we go.
Yeah, we changed the setting for the town hall. It's ready for you now, Miss Risa. You can send it through the chat.
Okay, thank you.
You're welcome.
So, Chair, I don't know if you recall going back to our previous conversations, but when I was in OIA, I did talk about this in a couple of commission meetings, even to the public about our desire. So it was centered around Task 45 of the NSA, which is disparity of discipline. And there was a broader conversation about how we can allow supervisors and commanders to be supervisors and commanders. But if you recall, there was the Stanford study, and there was disparity that was determined with discipline, and some officers of a particular race and gender being disciplined more. And it came from this. It's like, well, the question was, well, why was it even an internal affairs investigation? And that's how this came up. Is like, if we're calling it class 2, that supervisors can handle it in a formal way, but doesn't result in. So there is a little bit of background that is very coincidental to Deacon Lyles and what he brought up, and he's spot on with it, because this has been a kind of a lingering project of mine. So I do want to resurrect it, and maybe we can do it in this forum, because it does have a lot to do with what we're talking about.
And the challenge is having the flexibility to be able to classify something between level 1 and level 2, but then having the protective factors in place so that that level 2 designation doesn't get further exploited and get us into further trouble with that task 45 that has been an ongoing task. And speaking of task 45, hello.
Hi.
Marcia, former Chair Peterson, how are you? Glad you could join us.
I'm good.
Hey,
And
Marcia.
hi, Rich, and hi, Lieutenant Hubbard. Or are you now
I'm
the
acting captain today. Brian is fine too.
captain today? Okay. I'm sorry I'm late, but I don't get off till 6, and I can't get home sometimes any faster than now. But I'm glad to be here. Sorry I missed last time too.
Happy to have you.
Glad to see
Always.
Thank you.
So this, I think, is definitely going to take us a little bit more chewing on, it sounds like, and teasing out a bit.
Yeah, for sure.
Now, given it's going to take some significant time anyway to update this and then have it go through all the proper channels to get it, in place. Are there ways, to Deacon Lyle's point, to start working on building out those checks and balances, or putting those things in place so that when this does come down the pipe, those things are already built in to the apparatus, as Deacon Lyles has mentioned?
Yeah, we have a lot of room on that policy that I just mentioned, just because I do already have a draft of that, and I know the independent monitoring team have been involved because they've raised concerns over it. So we're already ahead. I would like to formally present it to all of you. I think, because it's right. I don't want us to categorize manual of rules sections without updating that policy, because it's putting the cart before the horse.
Gotcha. Makes sense.
Yeah, so maybe next week I can do a formal discussion on that, and then come back and look at it through the lens of this policy or what we're talking about here today, and see if it works.
Great.
I apologize, but for coming in the middle of this conversation, but can you give me a 1-minute synopsis of what it is we are concerned about?
Sure. We are currently talking about use of force, and as you know, we have 4 different levels of force, one level being the most extreme. So that's an officer, let's say, discharging their firearm. And level 4 would be the least intrusive use of force. The problem with our current manual of rules section regarding force is that it's all inclusive. So it says the use of physical force shall be restricted to circumstances specified by department policies and law. So there's only a class 1 section for this. It doesn't allow for procedural mistakes or tactical deficiencies of use of force. It only, so we were talking about creating a class 2 section that separates those types of events.
I see.
It then turned into a discussion of, well, if I do, let's say, handle it on my on a supervisory level, to Deacon Lyles's point, could we be masquerading class 1 violations as class 2s? And the answer is yes, that is a fear. And we've been in trouble for that before, where something we like, oh, that's not a big deal, let me just handle it informally, actually was a very big deal, and I should have handled it formally into an investigation. So that is a concern. Right before you,
That because the supervisor can have discretion to determine whether or not to treat it as a class 1?
if we call it a class 2, there's a policy that allows the sergeant to handle it, but they can easily mask things as not as serious when it really
Sure.
should have been a level 1.
I see.
Yeah.
Of course. Okay.
Yeah.
And I think it, if we're going to improve the organization, that the officers, sergeants, lieutenants all know that if they're playing footloose and trying to hide things, you're just going to make it more difficult on the organization and your career.
Yeah.
So, look, I got to take a stand here. I can make this a level 2, but I'm not. Why? Because last month you had a similar situation and we did make it a level 2.
Yeah.
And so now this is a level 1.
Right.
And that's it. And so I would need someone above me saying, you should have done this, or you should not have done this, or I agree with your decision, or whatever. And so that we have some kind of a unity of command there.
In other words, if you create an internal precedent, other officers will expect to be treated that way, when in fact it should be at a higher level.
And this precedent, we have to walk away from that, because every situation has its own merit.
Absolutely.
And so I'm not doing this because last month John wasn't made into a level 1 and yours is. Your situation is different from John. The results, the end, the severity is different. I'm making a decision based on the merits of this case, in this case alone. Now, I don't mind an officer learning and being taught, and I think we want the officers to be better as they mature as officers. However, I surely don't want a loophole where people are saying, "Hey, you didn't do it for John, so you can't do it to me." No.
And they will do that.
Yeah. Well, they can let them do it. We have to.
No, but I'm saying that's a common practice you find always in arbitrations.
Yeah, but here's the thing though. The organization has to stand up and say, we understand that. We understand you think that you should be treated one way because somebody else was treated another way 6 months ago. You don't know all the facts of that case.
Correct.
And so I'm saying your case is standing on its own. And when the department starts doing its own job in being a professional organization and disciplining itself, that's when we get rid of all of these oversights and all of that.
Correct. I got it.
That's how I see it.
Thank you.
Yeah. So we were saying we need to get the apparatus set up. We got to get, before we start making any changes here.
Okay. Got it. Thank you.
The checks and balance has to be in place and accepted.
Yep. Okay. Actually, that's that was the end of my task for the day, ending with use of force. I know I still have a lot of work on that, but just to recap what we talked about, subversive organizations, we're fine with what we came up with, but we do have another section that we created that is specific to associations with disreputable organizations that are not technically subversive. So I'll send that out just so you can have more time to digest it, but because it's pretty long. We did not change the truthfulness manual of rules section from last time we met, but we did add a juvenile specific section. It speaks to juvenile interactions, interviews, and also custodial interrogations. I am going to also carve this out to be this section right here, specific to juvenile interactions that aren't necessarily about interviews or interrogations, but just general conduct. And I'll put that in the 314 category. And then we wrapped up today talking about use of physical force level 1 through 4, creating a class 2 section. However, also now looking at our policy V as in Victor, T Tom 3, which talks about class 1 and class 2s and how one needs to be reported to internal affairs, but one can be handled formally by a supervisor or commander by way of a supervisory note file. So I will present on that next week, but I'll send you a draft copy just so you can see what it says. Anything else that for the next, anything I can work on between now and next week, or anything further we can talk about tonight since we have a lot of time left?
Yeah, no, thank you for that. And when you do send this out, Captain, Miss Marcia, definitely pay attention to the area on the truthfulness around juveniles, because I know you were part of that original discussion. We had some extension discussion around that a couple of weeks ago. There's a lot of work done on that, so I'm happy about that for sure. No, I think this is a good place to pause now. As where are we at, Captain, with like the next section of MORs? Is like, does this sum up a particular section that we're on, or do we still have quite a bit of things that we still now have to move into from here?
We actually, the last one, and we did talk about this, refusal to provide name or serial number, we chose not to change anything. That's upon request, members and employees shall supply their names and serial numbers and to any person who seeks such identification. We did have a discussion about is it plausible that the officer did not hear the person make that request? And right now, similar to use of force, there's only a class 1 section for this. And I shared examples of these are true stories where it was just a chaotic scene, and a person asked for a name and serial number, and it's plausible that the officer did not hear the person. So then it's an argument over whether it is indeed plausible. So we talked about situations where it's like there's no intentionality behind it, but it is indeed still a violation. But we concluded with not changing this section at all.
Okay, great.
And that wraps up actually the heavier ones. So I'll have to go through our manual rules section again and just pick out those that are in the next tier to discuss. But I think we covered all the big ones.
Can I ask a question? This might be very naive. Do officers carry cards with their name, their badge number, and other important and pertinent identification information, such that when they come on the scene, they could just, this is the information that you may seek with respect to who I am and what, and how you can follow up. Because I do appreciate, there's a lot of chaos. A lot of people may be gathering around, shouting, crying, screaming, whatever the situation might be. And who's yelling? Who are you? What's your name? What's your serial number? Is not something the officer is necessarily focused on, but I think it's very important that up front, that information is given, whether or not asked or not. And I know there's a lot of repercussion if you don't give your name and you're saying, oh, they may not hear it, it's very chaotic, it's noisy.
Service area.
I think it's a lot on the officer to have to stop and do that when they could just give a card. I mean, that might be a naive suggestion, but that's how I see it.
And the sponsor piece is another one that the sponsor
it's not feasible.
I know she lives here.
That's the argument, is the non-feasibility. There's no excuse for officers when asked to provide their name and serial number, and we have that expectations. That's very clear. The issues that we have are like an officer is literally fighting with someone, and someone who's watching this fight go on saying, hey, what's your name and serial number? And at the end of the encounter, we then, hey, officer, why didn't you give your name and serial number? And they say, well, I honestly, I was completely distracted with fighting with this other individual. And so then the debate happens of like whether the officer should have processed it, even when the emotions come down, and still given their name and serial number. So
during, okay, but before leaving the scene, why can't this be given, at least the officers know that before they leave the scene, they provide whoever wants this information, that information. And it could be on a card.
Doing for one what you do the other. If it doesn't
yeah.
happen,
I'm just curious.
Yeah, no, that's a great question. I think it's in a somewhat reasonable scene. I don't think that's unreasonable, but if we have a scene where there's 20 officers and a few dozen people, like how are all the officers doing that? Who's facilitating that? It's one of those like broader question or scenarios where it's not as clean as you and I are talking. I can easily hand you my information before we part ways. Sometimes these scenes are just so chaotic that we're not processing, okay, that person on the corner that I never had any interaction with, should I walk over there and just give him my name just in case they did ask for my name and badge number?
I appreciate the chaotic situations that officers will enter into, and yet I do want them to make sure they give their name and serial number and it says to any person who seeks such identification. That's kind of hard, but I think when come on the scene, and I know sometimes they come on the scene, jump out of the car, and they're running after someone. So,
but you're not saying they should come on the scene, not jump out the car and run after somebody because they got to give out their name and
no,
because somebody, hey, before you run after them.
No. I'm not saying that. I'm not saying that at all. I'm just trying to find a way that information can be given and not be required at the actual time someone asks, but at least before they leave the scene.
Yes.
Yeah, that's fair too. And we've had that before where an officer does process that this person asked for their name and serial number. The officer got distracted and then legitimately forgot. So we've had those situations also where an officer has been sustained for this section. But then it's like, do we want to keep it as a class 1? Because there's no in between here. It's as in, you ask me for my name and serial number and I say, absolutely not, I'm not giving it to you. That's a pretty severe sustained violation of this section versus me forgetting to give it to you because I got distracted with other things. Those two, because there's only one section here, they carry equal weight.
But you know what? I don't believe they forget. It's hard for me to believe that officers don't know that's what they have to do. Now, what is the continuum through which that is required is a different thing.
Yeah.
But they have to know, they have to give their name and serial number.
Yeah.
So anyway, just curious. I've been curious about this since I joined the commission, that in the heat of all that might be happening, that an officer will be dinged for this, because an officer should know they have to do this. It's just within what period of time. is it required? I think definitely before they leave the scene.
Yeah.
And
If
remind
they
me,
have to
Captain.
identify who asked them, you know, if it's anyone need my name, serial number, or ask for it, I'm here to give it to you at this point. Now that this is situation is calmed down, kind of thing. I don't know. Just curious.
Hey, Kathy,
I
how you
actually like
doing?
that suggestion as a general practice. Hey, Kathy, how you doing?
I'm well and glad to be here. My other meeting ended a little early, so I was able to join you all today. Thank you.
Excellent, excellent. We are covering the last item of these batches that we've gone through. Captain Hubbard is going to send this back out to the group so that we could, because quite a lot of work was done between the last two meetings, so that we could kind of digest this again and process it for the next meeting as well. And in talking about refusal to provide name or serial number, did we not have a discussion about having this be a class 2 option as well on this one, or are we just discussing that for the first time right now?
We
Because I
did.
thought this was one of the ones that we talked about would be good to possibly explore having a class 2 for this as well.
Yeah, my notes, we settled on not changing it, but you know, that was from the last meeting. Yeah.
Oh, we did settle on not changing it, on not having a class 2.
That's right.
Yeah.
I remember
But
that too from the last meeting.
Okay.
Yeah,
So it
I don't
will
think
be
you
a
ought to-
class 1
It remains as a
violation.
yeah.
Yeah, you got your name on your uniform. You got a number on your badge. That's there for a reason. You are to be identified. So if somebody asks you for your name or whatever, tell them. And don't empower them by you having an ego trip and not telling them.
I understand that arrogance and not giving it if you
Yeah.
have heard the person. But if you jump out the car, you're chasing someone, you're wrestling someone to the ground, trying to put the handcuffs on, and someone saying, "What's your name? What's your serial number? What's your name? Serial number?"
That's
That's a
mitigating.
different thing.
Yeah, that's mitigating. And I'm not stopping to talk to anybody about who I am or whatever until everything is safe and et cetera. And I think I would hope that the sergeants, lieutenants, and captains would understand that. Would say, yeah, well, you know, you were trying to effect an arrest or keep people
Yeah,
away from each other, you know, maintain order. And so, yeah, you ain't got time to to do that. But at some point, if someone says, "What's your name?" where we get into the issue, I've seen it over and over. I don't have to tell you anything. You know? Yes, you do. You're the one in the uniform. Yes, you do.
I'm not trying to understand that one. I think that's a clear violation.
Yeah. That's the overwhelming, from my experience, what I've seen, it's always that.
Got it. Thank you.
You know.
but in that case, that once in a blue moon, rare occasion, let's say somebody was, and this is just more of a question, right? And just helping me understand this. Let's say there was just existential circumstances in which somebody asked for their name, they're about to make an arrest, and then shots are fired at the officers, and the guy takes off, and then, you know, and then an arrest isn't made to another hour later or something, and then technically that guy never provided his serial number, but you see that on body worn camera that it was never provided. Like, I guess in those very rare circumstances, would somebody have discretion to say, "Oh no, that wasn't actually a class 1 violation," or would they be forced to say, "No, we saw it on, he didn't provide it, it's a class 1, sorry."
I don't even think that's a violation. You know, I'm you stop the guy and using your scenario, and shots are fired, they're running away. And, you know, this ain't the time for identifying, you know, who was there, whatever. The department can give the person name. I mean, if a citizen says, "Look, I wanted to know who was involved there," I don't know why the department won't say, well, it was Officer Lyles, he was on the scene, and here are the other 4 officers on the scene. The dispatching of the officers and the officers who are arriving on the scene, that has to be kept, if I'm not mistaken, under California law for at least 100 days. So the department can share that name and who was who and et cetera, and who was involved.
I guess what I'm getting at is if a supervisor is reviewing body-worn camera because the shots were fired and the other circumstances, but they realize that a name was never provided at any point and then an arrest happened down the line, would they be forced to technically say, no, I've witnessed this now on my own. It's technically I have to violate him for this now. And I guess that's if the answer is yes to that, then it feels like we might have to consider a class 2 on this one as well. I see you're nodding your head, Brian. So I'm just, to me, was this a question? Or, I mean, it'd be great if like supervisory had that discretion to say, oh no, there was never even a violation. We understand those crazy circumstances, but if the video says otherwise.
Okay. If you are trying to arrest someone and there's some violence involved, gunplay and all of that, and chasing people down the street and all of that, that's not the time for, passing out business cards. It's just not the time for it. Now, if the person comes and says, I want to make a complaint because I asked an officer to give his name and he didn't do it, supervisor goes through it, does the investigation and says, this is not even a violation. Let me give you the person's, his name was Reginald Lyles. That's who he is. Now that you know who it is it anything else I can help you with? See, I don't think it. I think it should remain a class 1, and the people who overwhelmingly get caught up in this are the arrogant officers who just feel like I don't have to talk to you. I'm not going to act as if I have to respect you as a as a citizen, and so I'm not giving you my name. And so that's why there was a time when there was no names on uniforms. There was a time when there were no numbers on the sides of helmets and on badges. And I remember that time. And people actually said, no, we're not having these unknown people come out in uniform. We can't distinguish who's who and do all kinds of actions. So no, we want to know who they are and they have to identify themselves. And that's what we want. There was a time when there was no knock notice. And we said, no, you got to let people know that you're the police. So the folks who play fast and loose with this don't deserve a class 2. They know what they're doing. It's a class 1. And but if you are involving keeping the peace or defending the public or trying to maintain order, whatever, you ain't got time to pass out no cards. So if the person comes to the station and said, who are the officers at the scene? The department ought to tell them. The department knows who was there.
I think, but that's the problem, because sometimes the department won't reveal the name of officers.
And there's the problem.
I remember a time when I asked an officer for some information, and he covered his badge, and so I couldn't tell. Now, luckily, I had already looked at it first, and so I knew who he was.
Yeah,
but I've certainly been in that situation, but I'm also I'm thinking if an officer is engaged in a chase or he's trying to arrest someone legally, and I agree that he doesn't have an opportunity at that point to give out his information because he's trying to effect an arrest, whatever he's trying to do. However, at some point his name should be divulged. If he can't give it on the scene, then OPD should reveal that name. And
Exactly.
we see all the time where those names are not being revealed. They'll give the name of a suspect to a newspaper outlet, but they never give the names of the officers. And I think that
And
that's not fair.
well, giving names is their obligation because like I said, you know, if they dispatch someone to a location, I don't know the numbers or whatever, 132 56 in Grove and 156, all that, they know who that is. And you have to keep those tapes for 100 days for the sole purpose of determining who was involved. If OPD has a policy or an unwritten attitude that we don't want to give out who was involved, they're in violation of the law. You have a right to know.
Well, it's, if I might say, it says refusal to provide name. That's different than not providing the name during the effect of arrest or something. You're in the throes of that. So why can't we change this to say upon request, members, employees, and OPD, who would we, command staff, shall supply their names and serial numbers to any person who seeks such identification on the scene or through official channels.
Now, the Police Officer Bill of Rights comes in conflict with that. You can't give the names of officers and to the press, etc. There's where it gets a little gray. Or am I presenting myself as a citizen, or do I work for, well, I know it doesn't exist any longer, but the Oakland Tribune, and that would be a violation of the Police Officer Bill of Rights. But if a citizen says, there were two officers down at my house at 5 o'clock today, there was a fight in front of the house, and one of the officers got up and I asked him for his name, he refused to give it to me. OPD ought to divulge it.
Well, how do we reach that? I guess that's what we're
well, I may not have it. I may not have it, the how completely worked out yet, but I know this should not be reduced to a 2.
I don't disagree if it's a blatant refusal.
Well, refusal is not just, I refuse to give it to you. Refusal can be, I'm avoiding you. Or refusal is like, nah. It could be all kind of things in refusing to give. So
I appreciate that, because it would be the totality of the circumstances.
Yeah.
Whether you see whether or not the officer in effect refused.
But you don't help the situation by making this a 2. This is the one thing that every officer ought to understand.
Yes.
The very reason why you got a number on your badge and and a name boldly on your shirt is for your identification. So why are you working against us? Get over it.
I think in all the scenarios we're discussing, I think we're all in agreement that there shouldn't be a class 2 designation for any of those circumstances.
Okay.
And I think what we're trying to figure out, and I guess the question is there a reasonable circumstance in which like a common procedural type of mistake could happen where it's not necessarily a class 1? We've established that for like use of force in other areas, right? And I think the question is, like, if there's not a situation in which we could imagine where an honest mistake could happen, where it could be, we could consider a class 2 violation, then yes, I think we should just keep them as class 1s. And I guess that was my question of my wild scenario, was like trying to think of like, are there extenuating circumstances, as few and far in between as they may arise, where the body cam showed that they were in the active duty, it was an honest mistake, they may have forgotten because of the circumstance. Again, like when I the scenario I gave where shots were ended up getting fired or something, right? I just, in the disciplinary process, I want to be sure that whether it's IAD looking at body cam footage, whether it's CIPRA looking at body cam footage, right? Where if there's somebody that's going to be like, see something where somebody was actually doing something in the interest of public safety and then they get dinged for a procedural misstep, it ends up being a class 1 violation. I guess that's what I'm trying to avoid. But
no, I guess I'm agreeing with you. I don't think that's a violation at all. Okay.
Well, me neither. But I guess my question to Brian was, is somebody else going to determine that it was?
No.
Or be forced to determine that it was?
No, listen, if the officer was involved in doing his police work and shots fired, whatever scenario you described, and he did not give out his name because he was in wrestling on the ground or whatever, that's not refusing. But if somebody comes up and says, I want to know who the officer was wrestling with my grandson, on my lawn, who was that officer? A department ought to tell them who that is.
Does this policy cover that scenario, or is that a different circumstance? This is just more in the moment of an actual scene. But
again, I'm trying to. Okay, the officer has to do his job, right? And you want to know the name of the officer, so we're going to get you that name. And so there's no reason for you to feel like you've been denied what you wanted. You've been given.
That's reasonable.
And the department has to give it to you. But I don't want to. I want to be careful about, because I know Government Code 3300 has an element in there about giving names out to officers to the press, and we don't want it. We don't want that. But if I establish myself as that, I asked him for his name, he wouldn't give it to me. I couldn't get it at the time because he was wrestling with the guy. Who was the officer that was, beating my son up? We should identify that guy. You leave this as it is.
Okay. Well, again, exploring the bandwidth, the possible bandwidth, and understanding the limitations of how this type of information can be given out. Again, I am not saying that this should not be a class 1. I'm just, as a layperson, trying to understand how could it also not be a class 1. And I think there are enough safeguards, including the body-worn camera, to determine whether or not this was a blatant refusal or there were extenuating circumstances.
And if there's extenuating circumstances, then it's not a refusal. It's extenuating circumstances. But to Kathy's point, well, then who is the officer? The department ought to say the officer was John Smith.
Yeah, I agree. That's a bigger issue in terms of transparency, and if they have to give their name on the scene, why wouldn't they give a parent or somebody else their name, on the back end? And I guess and I don't know if that's contingent on an actual investigation being open at that point or all the other circumstances. But again, I think going back to just in the moment on the scene, providing the name, if the rule, I don't know. I could be mistaken, but I could have sworn I've seen it in times where there could have been discretion where, like, oh, it was an honest mistake. Oh, they were shot. I don't know what the circumstances were, but a violation's a violation and they got to be violated, right? So I don't know if that's the case, what kind of discretion folks have when whether it's, and in all honesty, I don't know if there's people looking at those technical violations, just like we talked about in use of force, right? I don't want to have there be a situation where there could be discretion where, like, no, clearly everybody's in agreement. There was shots fired. Like, it wasn't reasonable for him to provide the name there, but the guy did ask for the name, and that name was never provided in a reasonable time afterwards because he forgot afterwards. And a half hour later, once they apprehended him, and a violation's a violation. Whether it's, again, whether it's IAD that's reviewing the body cam or somebody like SIP reviewing body cam, if folks are forced to that hey, the rules are the rules and we're gonna have to, it's a violation, then, and it doesn't take into account certain circumstances in that way, then it almost feels like there may have to be a class 2 in those extenuating circumstances. I just can't, I don't know why I can't get past that right now. And I don't know, I'm curious to hear what other folks think about that.
I'm afraid of loopholes.
Yeah,
Yeah, me too. And
That
when
is my
Reggie
greatest
brought that up
fear.
too.
I don't.
And so that's why I think that this should be a class 1. However, if the officer is unable to give his information because of extenuating circumstances or exigent circumstances at the scene, if the department doesn't provide that information later on, then who do you hold responsible for that?
The department.
Great question.
The department as a whole.
The
But you
department,
can't bring
yes.
the
Right.
department before-
Exactly. You can't hold that individual officer
The department.
responsible at the time because he was engaged in effecting an arrest or
Exactly.
whatever he was doing. Then it would fall upon the department itself and not that officer to be disciplined.
And
That's
the
the way I
conversation ought to be with the chief of police. What is going on here? Why what are you trying to, you're not helping. You're supposed to help the relationship between your department and the community at large, and you're not helping. You're hurting it. And so I don't think I think it should be class 1. I've said it redundantly, but if you have an officer that was wrestling around and you didn't hear whatever, he was excited or whatever, and you say, okay, look, as I was looking at the tapes and people were asking you for your name, you had opportunity, it seems to me, to have said something about who you were. You did not, and I want to know why. And that's a counseling session. That's not discipline. You know, that's counseling. And so
But could that lead to disparities if I have counseling sessions all the time with my white male staff, but my folks of color and female staff, they,
of course it,
so
of course it can. That's why we were saying earlier
same checks
that
and
we ought to
balances.
set up the apparatus,
Mm-hmm.
first, because I would want, if you, that sergeant you were alluding to that only has counseling sessions, there should be ones with certain people, and everybody else actually receive ones. Then that should be caught by the lieutenant. And if it's not caught by the lieutenant, then lieutenant, why aren't you catching this? And then captain, why are you allowing this to happen? So if everybody understands that we're in this together, then, no, I'm not taking a bullet for you. If you're gonna follow the rules and everything, we ain't got a problem. But if you're gonna not follow the rules and think I'm gonna cover for you, we got a big problem. So
and I think a larger issue too is if the department, as they say, are trying to regain or to build trust. I'm not going to say regain, but to build trust with the community. Then you've got to reveal who you are, and the community is not going to trust you if you're playing this you're hiding your identity, and then superior officers are backing you up on that. Then we'll never get to any trust with the department.
Well,
it's got to start somewhere. It has to start with, if you come in the community and someone asks you for your name, unless you're involved in some dangerous work right then and there, you should reveal your name and start the process of building trust with the community.
But isn't that begging the issue, the cultural problem we have with those layers that tend to cover up what's going on, and until we deal with those layers,
that's what we were saying prior to coming on, that we need to establish exactly what you're suggesting, that accountability from the layers and work our way down, you know, and so we have to, that's my humble suggestion is that's the way we should go. We should set up in writing what the lieutenant should do, what the sergeant should do, or the latitude they have, and what the lieutenant should do. If you're making everything a counseling session when it should be a one, I got a problem with you, and I got a problem with you in your career. You know, that's how I see.
For the detour and the education here.
One idea is not to change it from or add a class 2, but just elaborate more on the definition. And just so you know how we do our investigations, and this is somewhat of a frustration for me as the captain of internal affairs, is having investigators understand what they're investigating. So if someone said to me, hey, I'm investigating this officer for this section, what should I do? I'm going to say, well, let's look at the definition. It is, upon request, members and employees shall supply their names and serial numbers to any person who seeks such identification. So they say, well, what about an exigent circumstance? I'm like, it doesn't say that here. That's a mitigating circumstance. Well, what about if they didn't hear it? Well, the crux of the discussion or your interview is the upon request is like, well, did they hear the request? Did they process the request? So the problem is that I know we're giving a lot of hypotheticals, but at the end of the day, if it doesn't have it in the definition, then we can't make a decision based on it. We're only looking at it from this one sentence right here. So an option is just to develop this more. I know I appreciate Ms. Letters. We don't want to create loopholes, but if we do want to have a narrow consideration for exigency, then that's the place to put it, is in the definition.
I don't know if we would limit it to just exigency, but the totality of the circumstances. Now, that might be too ambiguous as well, because totality of the circumstances from whose perspective. If we have a lieutenant who feels, well, you know, too much was going on, and yeah, he heard it, but too much was going on, and he gets a pass, he gets a counseling. So we're kind of like damned if we do, damned if we don't. And we are creating loopholes, and I hate loopholes too.
Well,
Yeah.
They drive Mack trucks through those loopholes.
Yeah, I don't want loopholes either, and I don't know how. I don't think the exigency is unreasonable. I didn't have time to give it to him. I was on my back fighting for my life.
Right.
You know that. You know, then you haven't violated this, as far as I'm concerned. You haven't violated anything. Now you want to know whoever is asking for who was that officer, tell them.
But then you said that it violates the police officers' Bill of Rights if we.
No, I said to the press. Specifically to the press.
Specifically to the press.
Yes.
So
3,300.
This section will also encourage officers to always turn their cams on.
Yeah.
Their body cameras on.
That protects them for sure. And
yeah.
Can a person who is a member of the press present themselves as a citizen asking for the information?
Yes, they can.
So that's trickery. We're providing the information and maybe you're violating the officer's rights. So what I'm hearing is there are circumstances under which this would not be a class 1.
No.
Said the totality of the circumstances and the exit.
Listen, it's either class 1 or it's no violation at all. That's what I'm saying.
Okay.
If it's not a class 1, then the name was not refused. Well, I still don't know who the officer was involved. Come down here, we'll tell you. We have a record of all of this. We know who's involved. We know who went out on each case, who when they arrived, and what sergeant was there. So now, if you got a press pad, I'm looking up California's Bill of Rights now because I want to cite the section.
And Captain, in terms of a deliverable, it sounds like maybe it would be worth exploring what maybe a little bit more expanded language is on this if we keep it a class 1. Because yeah, we know the issues. I mean, I think I agree with a lot of this conversation. I think it's a great conversation. And so I think between looking at this section again, picking up with this section again, and then possibly identifying what the next group, because this is, and for Kathy and Marsh, I think Risa might have heard this as well too. This is the last MOR violation of the first batch of all the serious violations that we had started to look at. So once we're done with this one, then we're gonna have to identify what the next grouping is. Remember, we had grouped them in like most frequent and the most serious ones. So I guess we could look at this one again, close this one out, have anybody's last comments on the language from the other areas that you worked on from today's discussion. And then we could look at maybe the next set of groupings and how those are all broken out within the manual of rules, and maybe decide on what the next set are going to be for our next work, or maybe even just take a step back and just see where we're at and kind of recap with everything. I know we probably only made probably only a dent in the whole MOR, the actual manual itself. I mean, we've done quite a bit of work though. So maybe it would also be good to maybe reflect what we've covered so far and what's still left. Sure. So that we could look at a timeline as well. All right, awesome. I think this is probably a good place to pause. Are there any additional comments or closing thoughts about any of this? Checking the chat. Right. Well,
I'm at 3310 doing this fast read here.
Okay. Risa has her hands up. Let's go to Risa. We'll give you some time, Deacon, if there's anything you want to just review before we close out. Yeah, go ahead, Risa.
The chat was disabled again, but you finally got to the comment that I would have made in the chat. I mean, this understanding, the understanding of it's either a class 1, it's a 1, or it's not. I was just listening to this possibility of the loophole, and you're going around and around. We need to get to where that's a problem, where officers are being, oh, the word is escaping me, senior moment, more frequently, and then the rules need to be adjusted. But we are so far from there. So I was getting a little bit concerned when the loophole. So I was glad to hear Deacon Lyles stick with it. Thank you.
Excellent. Thank you, Risa. All right. This may be a good place to pause. Deacon Lyles, do want to wait for you because I know you're looking that up as well. So
yeah.
No rush.
Gosh. Byron, well, you're a captain. Am I wrong? Have the government code 3300 would prohibits giving identity to the press. Isn't that in the police officer's Bill of Rights?
Yeah, I think there are some like personal information type stuff, but like I don't think if it's a fit, like for officer involved shootings, we disclose that information. I mean, and to the previous example of like, if someone from the press came up to me and asked for my name and serial number, I'm not prohibited from giving it to them.
Okay.
But I have to look at it some more.
You know, I may be wrong on this. I thought it was you can't identify. I think you cannot identify a person that's in a that the department has filed a complaint against to the press. That's violates their bill of rights in California. So I don't see anything in here that prohibits identifying the officer who was at the scene where there was a fist fight, and the officer failed to because of the commotion and safety and all of that, failed to tell a person who asked him for his name. So if that person came to the station, asked who was there, the department ought to tell them. Oh, here it is. The employee shall not cause the public safety officer under interrogation to be subject to visits by the press or news media without his or her consent, nor shall his or her home address or photograph be given to the press or news media without his or her express consent. So that's 3303 subsection E. So it does not apply. So they can go to the department and ask who are the officers that were at the scene, and the department ought to share that, because none of those officers are under any investigation for any violation of anything.
Well, that was.
And if I'm a member in the community and can't get that information, that's a bigger problem than the officer just forgetting on the scene.
And that's the very reason why we exist right now. We're trying to change the culture. We're trying to say, look, you would help yourself and all of us if you were more transparent. Just, okay, we understand you couldn't tell at the moment your name and all of that. You had more pressing things to think about. But now, a day later, who was at the scene?
So can we edit this in your consideration of any edit of this upon request? Members, employees, and I don't know who it would be. OPD command staff shall supply the names and serial numbers to any person who seeks such identification. Because that's what we're saying, is also the department has to release the information.
Yes.
The good thing is, no pressure, Captain, but every time we have fruitful discussions like this, we always come back and we see some of this captured in some of this work. So I really do appreciate a lot of the insights and discussion around these important areas.
So it does not, on record, because I know we're being recorded, what we're talking about does not violate Government Code 3303 subsection E as we're reading it, because the officer who should have identified himself is not under investigation or subject to interrogation. We're just trying to identify who was at the scene.
Right.
And that's public information. He wears his name on his shirt. He wears a number on his badge. If he has a helmet or whatever, he has a number on the helmet. And his car has a number.
So if we say the organization shall.
The organization shall identify him.
Right.
And so, we're trying to, I know this is redundant, but we're trying to get at that attitude of, I'm not telling you nothing. Why? Because I'm not telling you. That's the attitude we want to get rid of.
Correct.
Yeah, I'll
We're
have
a
to.
long way towards solving this one.
No, we did good, I think.
I think so too.
Yeah.
All right, I'll develop that some more.
All right, sounds good. Looks like we're at time at 7:55. Give folks these 5 minutes back, but appreciate everyone. Always great seeing folks.
Happy New Year.
Yeah, I don't think I've seen you guys all year. Hey.
Hey.
We're already
See you
well heading into
Sunday,
February,
Marcia.
so
What's that, Reg?
I see you Sunday.
Yes, you will. Absolutely. Absolutely. Okay.
take care. Good night, everyone.
I'm
Thank
out.
you all for your input. Good night and see you next time.
Okay. Bye-bye.
Good night.
Bye-bye.